Good afternoon, everyone. Welcome to the Delaware Public Service Commission meeting of November 9th. We have the reading of the meeting minutes of October 31st, 2017. Does anyone have any changes or corrections to the meeting minutes? A lot of thoughts going into that process.
Chair, I move that the commission accept the minutes of October 31st.
I second.
Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed? Any abstentions? The motion carries. The regular agenda, number 1. In the matter of the application of Delmarva Power and Light Company to revise the utility facility relocation charge rate to recover costs associated with the relocation of gas utility facilities. Mr. Willard.
Hi, yes, Commissioners. Again, this involved two cases, two of the gas cases. First one was filed back in November of 2015, asking for a UFRC rate increase of 0.21%. That was based on plant additions of over $1.5 million and some depreciation. It also sought recovery of an undercollection from a previous UFRC. Then the next case, 160672, was filed in May of 2016. It sought an increase of 0.25%, plant additions of $12,000 and depreciation. Also, this request in 151601 included Delmarva's reflecting $73,000 that had been disallowed by the Commission in an order in November of 2016. In any event, on May 31st, 2017, the staff began the reconciliation and audit. Customer bills were checked, and there found to be no problem with them. The building that was done was looked at, and it seemed to be in order. And staff recommends that the Commission approve the rate as collected between June 2016 and as collected between July 2015 and July 2016. And formally close these two dockets. And I believe the public advocate is in agreement with that, if I'm not mistaken.
We did have an opportunity to review the orders, and we had a question that actually did not get answered. So I guess I will ask it here, which is when the company files new rate cases, the UFRC is supposed to be zeroed out. So I am assuming that it was in fact zeroed out?
Should I
Mr.
respond?
Goodman?
Yes. Yes, Ms. Haggerty, when we do put the first interim rates into effect, it does get set to zero, and that was not only in the cover letter when we filed the interim rates, but it's also in the filing itself.
Okay.
So you are correct.
All right.
And it has been done.
Thank you. Then we don't have any objections.
Any further comments, Mr. Goodman?
No, I thank you, Mr. Willard. Stated well. I guess I would only just. Sometimes it's hard to remember what each thing is. UFRC is the utility facility relocation charge and applies only to recover costs when we are required to move for generally road projects, or new roads coming through or widening. And if it's not reimbursed as part of the project, that's the only thing that those costs are for. But I'm obviously in full agreement with Mr. Willard's recitation.
Commissioners, any questions? We've got Mr. DeLosa who would love to talk if you have a question about it.
I'll move that we adopt order number 9144 as presented.
I second.
Any discussion on the motion? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries.
Thank you.
all. Number 2 is in the matter of the application of Delmarva Power and Light Company to establish the rate for the utility facility relocation charge. Mr. Willard.
Yes, this is the electric UFRC case of Delmarva. Again, they filed an application in November of 2015, amended it in December of 2015. They sought 0.36%. This was based on plant additions of over $3.3 million, and the Commission approved that on December 15th of 2015 in order number 8838. In April of 2016, staff began the annual audit and reconciliation. And in May, they returned to DP&L to complete the annual audit. And DP&L provided revenues pertaining to their electric UFRC for the period January of 16 to December of 16. And staff reviewed everything, the plan additions, they found no errors there. They reviewed the customer bills, they found no discrepancies. There was an over collection of $89,775.23, and that's been applied to the rate calculation in a new case, case number 17-0401, which was submitted in May of 2017. So the staff recommends approval of this and the closing of this docket, and of course, Pam is here to answer any questions you have.
Ms. Iori?
Thank you, Chairman. So we have the same question with this one as we had with the gas one. I assume the answer is going to be the same. So,
Same answer, Ms. Iori, yes.
So with that, we don't have any objection.
Thank you, Ms. Iori. Mr. Goodman, anything further?
No, this is just to approve, the past one that is now set to zero. And again, it's only the cost of when we are required to move facilities for generally a road project, sometimes for sidewalks or sewers or something. But I 100% agree with Mr. Willie.
Thank you, Mr. Goodman. Commissioners, any questions? May we have a motion?
So I move that we approve order number 9138 and close the docket.
Second the motion.
Is there any discussion on the motion to approve the order? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries.
Thank you.
Thank you. Excuse me. In the matter of the application of Comcast Delmarva Incorporated for the commencement of proceedings regarding the renewal of the cable television franchise to certain unincorporated areas of Newcastle County, Kent, and Sussex counties. Mr. Walsh.
Thank you, Chair Winslow, Commissioners. This is proposed order number 9145, Comcast of Delmarva, which on October 25th filed a timely application to renew their franchise, begin that process via this opening order. And this order does the following. It will open the docket for consideration for the franchise renewal. It also appoints hearing examiner A as hearing examiner for 2 public sessions. Comments, objections from the public due on February 16th, 2018. Petitions intervened due January 4th, 2018. We originally had that on the 1st. We thought it prudent to bump that out a couple of days. Of course, there's the Exhibit A attached, which Comcast will have to publish timely and submit to the Commission an affidavit of publication before December 30th, 2017. And Comcast may also submit a proposal for renewal ultimately before September 15th, 2018, at which point staff will review and submit its analysis to the hearing examiner. The hearing examiner will then file a report, memorializing public comment sessions, either recommend approval or the alternative recommend that a evidentiary hearing be held on the matter. We have reviewed this, of course, with Comcast, with the public advocate, and we order 9143 memorializes consensus parties in agreement. We would respectfully request that the Commission approve the order.
Thank you, Mr. Walsh. Ms. Iori, do you have any comments?
I do not.
Thank you. Commissioners, any questions? Do we have a motion?
Move we approve order number 9145 as presented.
Second the motion.
Any discussion on the motion to approve 9145? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Thank you, Mr. Walsh. I guess Comcast was pretty confident that it was going to get started. Hearing schedule. Excuse me. We have next is number 4 is in the matter of the application of Delmarva Power. That was 40. I think I probably would like to skip this one.
I was thinking that.
In the matter of the application of Delmarva Power and Light Company for an increase in electric base rates and miscellaneous tariff changes, also known as the case that continues to give. And then we have the parties come to the front so we can hear from them. We have received extensive briefing from everyone, and we've also received some not extensive but very good briefing from some, and also we acknowledge a letter from Representative Collecto as well. So, Mr. Geddes has been detained, unfortunately, because of transportation issues. I understand. He says it's a joint submission by the staff. I think it's highly appropriate for this. I will carry the order for both sides, both members of the team, and start off with the comments taken into consideration the fact that we have read your very fine brief.
Thank you, Chair Wessel and Commissioners. Actually, this will be the argument will be a joint effort as well. I would request some time for rebuttal if necessary, and if necessary, Mr. Walsh will be giving a rebuttal.
Yes.
I hope to keep this as short as possible. Delmarva, I think, is going to paint this as nothing more than a scheduling dispute and take staff of the EPA to task for not discussing a revised schedule. But we believe that this is more than a mere scheduling dispute. The reason that we're here today, and the reason that staff in the DPA were unwilling to negotiate a new procedural schedule, is because the company does not accept that its supplemental testimony constitutes a new rate filing. Instead, it suggests that its October 18th filing is just a modification to an existing schedule, rather than recognizing that this is a substantial change from the case that it filed in August. So accordingly, we think it's important for this commission to decide what constitutes a new rate case. Staff in the DPA and all the interveners believe that the supplemental filing is a new rate case. Delmarva says it is not, and that is what you are going to have to decide today. I'd like to begin with some background that provides a framework for why this has become the cause célèbre that it has, because I think it's important for you to have a sense of how we got here. Before Delmarva filed this case, it met with staff in DPA and expressed its desire to process this case faster than cases have been processed before. We never seemed to get a case completed within the 7-month statutory period, but Delmarva wanted to try to reduce the length that of time that it's taken in past cases. And staff in the DPA were not opposed to that. We'd like to process cases faster too, but not at the expense of a complete and thorough examination of what has been filed in support of a utilities request. And we acknowledge that much of the delay occurs at the beginning of the case and is due to the logistics of state procurement. Staff in the DPA have to file RFPs, get approval to enter into contracts with consultants, and our consultants can't begin to work without a signed contract in place. But we promised to do whatever we could to speed up the process. And one of the things that we told Delmarva was that it would be helpful if it provided some of the information that we normally request in discovery up front at the time it filed its application or shortly thereafter. Delmarva reviewed discovery from previous cases and identified data requests that staff or the DPA had asked in all of its previous cases. And that's what Delmarva calls the voluntary discovery. And as an aside, Delmarva makes kind of a big deal about it, as if it was providing this information out of the kindness of its heart. But the fact is that staff at DPA would have asked for this information if the case was proceeding as usual, they would have asked for it in their initial discovery request. So it's not like they were giving us anything we wouldn't have gotten anyway, we just got it faster. But I digress. So, I don't know whether you can see it because we're kind of on an angle, but without the pencil in it. This is what Delmarva filed as its original application. And this includes all of the minimum filing requirements and Delmarva's work paper supporting its adjustments. This file supported a requested revenue requirement increase of $24.4 million based on a test period consisting of 3 months of actual data and 9 months projected data, although witness Sininsky's pre-filed direct testimony suggests that it was 5 months of actual data and 7 months of projections. However, the index of schedules in the minimum filing requirements says that it's a 3.9, 3 months actual, 9 months forecasted data. Now, the parties worked hard to put together a procedural schedule that accommodated the schedules of the parties' witnesses and counsel, but processed the case faster. The deadline for interveners to respond to to file initial discovery was September 27th. Delmarva's responses were due on October 13th. On October 17th, 2 months after Delmarva filed its initial application, and 4 days after Delmarva's responses to initial discovery requests were due, my client received a call from Delmarva to alert him to a filing that Delmarva would be making. According to Delmarva, there was an error in the original cost of service, along with an error where the synergy savings were not zeroed out as part of the merger commitment. Staff's executive director received a similar call from Delmarva saying the same thing. So we were told a day before the supplemental filing was made that it was correcting errors in the original filing. Correcting these errors resulted in an increase in the requested revenue requirement from $24.4 million to $31.2 million. That is a difference of $6.8 million and represents an almost 30% increase in the requested revenue requirement. That 30% increase in the requested revenue requirement is huge. Now Delmarva says that, well, the supplemental filing was really only an update to provide actual data. And on October 31st, Delmarva filed an errata saying that, notwithstanding Mr. Zininsky's supplemental testimony on October 18th, saying that it's an update to 6 months actual data and 6 months projected data, it's really an update to 8 months actual data and 4 months projected. And that's apparently so it can try to squeeze itself into compliance with the Commission regulations requiring updates to actuals 60 days after the close of the quarter. So in just 2 weeks, this case became a moving target. The revenue requirement increase was $24.4 million. No, now it's $31.2 million. The reason for the supplemental filing is to correct errors in the initial filing. No, now the reason for the increase is updates to actuals. But this isn't just an update to actuals. If it does, that doesn't say much for Delmarva's ability to project to the end of the test period. $6.8 million is a long way up to the off projections. From what we understand, the update to reflect actuals only accounts for a minor portion of this $6.8 million increase, regardless of how many months of actuals it represents. It appears that the majority of the change in requested new rates results from errors, mistakes in the original filing. But we haven't had the opportunity to review it in detail and haven't had the opportunity to date to ask any discovery with respect to it. But let's just assume for purposes of argument that it really is just an update to actuals. I've been doing this for a long time, longer than I should admit. But in my decades of appearing before the Commission and in all the rate cases in which I've participated, I've never seen an update to actuals that increased the original revenue requirement request by almost 30%. This so-called supplemental filing, in reality, is a new rate case. It will have a significant and substantial effect on the proposed rates, but nothing in the supplemental filing tells you what that effect will be. It contains no new tariff sheets showing what the rates falling out of this new revenue requirement will be. It includes nothing addressing the impact of this increase on class cost of service, revenue allocation, or rate design. It contains no supplemental testimony or schedules from either its cost of service witness or its rate design witness. It came long after the public notice of its initial filing had been published and only a few days before the public comment sessions were scheduled to take place. And it was submitted well after the deadline for initial discovery requests and just 2 weeks before follow-up discovery requests were due. Again, Delmarva will say it would have given us more time. It was willing to change the schedule. But we already had a schedule in place. That schedule provided for direct testimony from interveners and rebuttal testimony from Delmarva. It contained no provision or placeholder for supplemental filings, especially without the hearing examiner's permission, nor did it provide for an opportunity for Delmarva to amend its filing by an almost $7 million increase in the requested revenue requirement. So this was the pile of documents that was the original filing. This pile consists of what Delmarva filed on the 18th of last month, which is this much, the supplemental filing, plus the voluntary discovery that went with that filing, which we didn't receive until a week or so after the supplemental testimony was filed. This pile also includes all of the minimum filing requirement schedules that we identified in our reply papers that would require updating as a result of the increase in the requested revenue requirement. This pile of material also includes the direct testimony and schedules from witnesses Seth, Cecilia, and Chanos that would require updating as a result of the increase in the requested revenue requirement. And finally, it includes the tariff sheets that will require updating as a result of the increase in the requested revenue requirement. Now, the cost of capital testimony didn't change. That is probably about that much of what's in the blue books. So you can see for yourselves that what changed, or should have changed, is about 2/3 the size of the original filing. Now, you may recall that in the recent oral argument on whether to allow Artesian to record a regulatory asset for legal expenses, Artesian's lawyer told you that utilities are watching what you do. They are indeed watching what you do. We understand that mistakes happen. We are not trying to punish the company for making a mistake. But the mistake was Delmarva's. It wasn't ours. And Delmarva has to own it. If you decide that Delmarva's supplemental filing is not a new rate case, you open the door to all utilities filing new revenue requirement requests in the guise of updates to actuals or supplemental testimony without submitting supported minimum filing requirement schedules and cost of service or rate design impact or new tariff sheets. You also open the door to them doing so at any point in the proceedings up to rebuttal. As we stated in our papers, we don't think the law supports that conclusion, and we don't think that fairness to non-utility parties supports it either. In the end, this is your decision, but we respectfully request you to put that decision in the context of all the other regulated utilities for which you, as a commission, are responsible. You created rules to administer rate cases. Those rules have not been followed here. We ask you to hold utilities accountable for not following what you have decided are reasonable requirements to balance the interests of all parties who are stakeholders in this process. We believe that to do otherwise would not be in the public interest that you, as a commission, are obligated to protect. So we respectfully request that the commission dismiss this case without prejudice and require Delmarva to refile its case. However, if you do not want to go that route, then we would alternatively request that you treat the October 18 filing as a new case and order the development of a new schedule that provides the parties with the same amount of time that they would have had to process the case using October 18 as the starting date for the application. Thank you.
Thank you, Ms. Nolan. You indicate that staff wants us to dismiss the case, excuse me, without prejudice. Are there some prejudicial things that will occur as a result of having to file a new application?
We wouldn't say that it was prejudicial. It would take more work on their part. They would need to file the minimum filing requirement schedules to conform to the updated revenue requirement. They will have to submit new tariff sheets. We submit they would have to do that anyway, because all of those things change as a result of $6.8 million increase. Cost of service changes, the class cost of service allocations are likely to change.
Is there a lot of expense attended with the dismissal and the new application?
I can't answer that question because I don't know how much it cost Delmarva to put together its initial application. All we know is what they're claiming total rate case expenses are. It's not broken out into initial application filing, direct, other discovery, rebuttal, etc.
Thank you. Mr. Skaggs?
Thank you, Chairman. If I could hand out some stuff that I think will help straighten out what appears to be confusion. Thank you. That's okay. I'm sorry. I should ask permission first to approach and to hand out. Yeah. Commissioners, Delmarva made a mistake.
Excuse my interruption, please, just for a moment. Sorry, Mr. Chair. Can we have the witness identify themselves? I'm sorry.
Oh, I'm sorry. R.J. Skaggs, Morris Nichols Arston Tunnel, outside counsel to Delmarva in this rate proceeding. With me is my in-house counterpart, Todd Goodman, and the witness who sponsored the testimony with the mistake and with the correction, Jay Zeminski. We wanted him here in case the commissioners have any questions about this, because we're going to walk you through and show you what that mistake was and why it's not of the proportions. It is a large dollar amount, but why it's not a particularly complicated correction. So you can see it for yourself instead of just going by a bunch of innuendo, splashed around this room today that could cost Delmarva a huge amount of money and effort to restart this case. So, once again, it was a mistake. And, of course, a utility never wants to make this kind of mistake in a filing. Takes responsibility for it. It understands it could and should move the schedule, should modify the schedule. So it can be digested, understood, and opposed if they want to by the other parties in the case. But does it rise to the level of dismissal? And we would say, quite frankly, of course not. So there's three levels here I'd like to address this on. One's the law, that of course matters, and the law, we would submit, the law of this commission provides no support for dismissal based on this mistake at this stage of the case. And in fact, staff and DPA have basically offered you none to support their motion. Second, the facts, which we will show you, that have been presented to you by staff and DPA unfortunately have a couple very basic errors in them that are really not beyond any reasonable, or not capable of reasonable dispute. I'll demonstrate those to you. And finally, we believe this commission has operated with a great sensitivity to practicalities of rate cases and basic fairness. And when you apply that to this situation, there would be no reason to take the harsh and, quite frankly, unprecedented step of dismissal of this case. It's not required. Dismissal would not be required to protect the interest of any party to this case or any customer. And I'll explain that to you. So first, about the mistake. And by the way, we're dealing with two different things in the supplemental filing. And I think, I don't want you to conflate those, but they came in the same filing. One is the mistake. And I'll show you that to you. The one single mistake that produced the $6.7 million increase in the revenue requirement. The other one is the update for 3 months of actual data, which all utilities are required under the minimum filing requirements to do if they use a projected, some period of their test period is a projected test period. And I'll show you the MFR that requires that, the rule that requires that. That update, which is done routinely by utilities who use projected test periods, does include a lot of paper. But that's normal and indeed required because you're going and putting in 3 more months of actual data and replacing projected data. So it does require that paper, and staff and DPA are used to it. It's required and done normally. But that was done along with the correction of the mistake. And so there's both there. There was no effort here to confuse the two, to claim it was first one and then the other. All that's just not true. So the timeline, August 17, application is filed. October 18, DPL files its updated actual data for June, July, August, and corrects the mistake. Staff does not raise any issue with DPL, request extension of the schedule to review the corrected data, or ask DPL any questions about the mistake or what's included in that. Nothing. Instead, DPA and staff moved to dismiss the entire case on October 24. The hearing examiner then pushes the decision to the commission, directly to the commission for decision. So, the mistake. It involves the cost to achieve merger synergies. Those costs to achieve are supposed to be placed into a deferred account, a regulatory asset, as it's called in these rooms, to be amortized over a period of years, instead of being charged as an expense directly into rates. The CTA are used in those years, amortized over years, as offsets to merger synergies, and then those net synergies, of course, are passed along to customers. In the initial filing, DPL applied the CTA both correctly as an offset for synergies, but also, and here's the mistake, unfortunately, it applied the CTA as a reduction to O&M expense. The applied amount, when everything's all worked out, is about the amount of the increase that was put in, about $6.7 million. It was
What is it?
$6.7 million. I'm sorry, I'm going too fast. This was a mistake. There's no claim here it's a systemic problem with DPL. There's no claim it was an application that otherwise did not meet the format and instructions of the minimum filing requirements. It did change the requested rate increase from 24 to 31 million. We certainly acknowledge that. The impact on residential customers at $24 million, the increase would be about $4.38 per month. For the $31 million, it would be about about $5.42 a month. So the difference between the two was about $1 a month, $1.04 a month, $12 a year. I'm not saying that's insignificant to some of the customers, but that's just to give you a sense of what this mistake is to the average customer. So you can see what it is. Oh, by the way, there are several assertions in the papers from staff and DPI I should clear up. In their motion to dismiss, paragraph 8, page 4, they say the correction purportedly corrects mistakes in prior cases. Not true. They don't cite anything for that. They don't explain that assertion. They just say this goes back in prior cases. It's not true. It's a correction in this mistake. It's a correction for this case. Staff and DPA assert that the correction required 80 pages of new exhibits. Not true. All the exhibits that were filed with the supplement were required by MFR 1.2.3, and I'll show you that, and that's what I was talking about, the required update of 3 months of actual data to replace 3 months of projected data. In this case, it was 3 months of actual data from June, July, and August of this year. And because you're replacing actual data for all across the board on so many different things that would affect the filing, it does require a lot of paper. So when they assert there's 80 pages for this correction, no, 3 were required. 3 different schedules were affected by this correction. So if we first look at, and I'd ask you to move to tab A in your notebook, and look at Mr. Zeminski's direct testimony. And I'll ask you to go to the schedules, and at the top right-hand corner will be electric schedule JCZ 16, adjustment 27. Pass this testimony to the schedules. It's basically back at the last page. Find tab A.
While you're looking, we're looking. As I already, Mr. Skaggs indicated that my recollection was there were 79 changes according to the joint submission. He's basically saying there's really only 3. Is that still a dispute there?
I'm sorry, 79 changes?
79 new schedules or something were required as a result of the filing?
No, I think he said that there were 80 changes.
Well, he said 80 pages. My recollection from the briefing, the joint submission was 79 pages. I don't mean to quibble over it, but is that really an issue now?
Oh, it's what, the number of pages isn't an issue.
Okay,
What the issue is,
right, substance.
okay,
Right.
yeah,
Okay.
substance.
Yeah, and so what we're saying is there were 80 new schedules or 79 filed. What we're saying is those were updated, the updates required by the rules. I'm going to show you just the very few entries that were required for the correction, so we're straight on that. And that would be the part that would not necessarily fall within what we would like to happen in a case. The other schedules that changed had to change because of the updating required under the rules. So if we go to adjustment 27, this schedule, and look at line 8, it's the heading is cost to achieve amortization and expense. 3 plus 9 months ending December 2017. On line 8, there's something that says total deferral of CTA expense included in test period. And you'll see in parentheses 6,076,732. If anybody's not with me, please let me know. Okay, so now if we go to tab B, that is Mr. Zeminski's supplemental testimony to the same schedule, last page in the back behind tab B. Basically, it'll be adjustment 27, and this time it'll be electric schedule JCZ S-16. Behind tab B. See? Yes, basically the second to last page, double-sided. Sure.
The first adjustment that you were looking at was behind tab A,
Yes,
and it's called adjustment,
27.
I don't have that page. I stopped at 26 behind tab A.
May I approach and hand you mine?
Does everybody else have adjustment?
I can share mine, I've got it right here.
Okay. I'm so sorry. Behind tab A should be an adjustment 27. Line 8, and there should be a $6 million figure there in parentheses. Yeah, it should be vertical adjustment 27 in the upper right-hand corner. You go down to line 8, total deferral of CTA expense in test period. If you look at if you go to the same schedule in the supplement, that will be behind tab B, and you'll see if you look at the first page, this is his supplemental direct testimony, where the testimony starts. But if you go once again to the next to the last page, adjustment 27, it's the same page except the supplement. I hope Commissioner Drexler has that one.
Oh, B 27? Yep, got it.
Good,
Just
okay.
don't have the comparison.
Now, at line 6, you will see, once again, adjustment to O&M expense. Add back June 2017 O&M credit for deferred expense approved in docket number 16-649, expense incurred in 2016, not in test period. You'll see a positive, not in parentheses, $5.7 million. Though that's the essential mistake. Now, as you work that through, and with the updated data that's coming in, and then when you also have to figure in the changes of the earnings on rate base, because these deferred assets become rate base, when you work all that through, it works out to 6.7. But I just wanted to show the commissioners the essential mistake, which was a plus and minus mistake. Not to say, we throw around pluses and minuses easily, or that we're proud of this, but that's it. It's not a far-ranging mistake that includes so many different entries that this case should start over. Certainly one that we believe staff and their experts can understand, investigate, and oppose if they want to with some reasonable time frame without the punitive measure of doing a start over. Okay? That's it, and it plays through.
Excuse me a second, Mr. Chair, may I?
Sure.
Mr. Skaggs, I
Yes,
have
sir.
a question on the schedule at the end of B, adjustment number 27. So, if I'm not mistaken, I think I heard that you had originally filed 5 months actual. You added 3 more for the requirements, which makes 8 months actual and 4 months projected. So, at the title line of this schedule, it says 6 plus 6 months. So, for me, that's confusing.
Yes, certainly. And the reason that was done, and this is what is cited, this is what has, I think, to some extent agitated staff and DPA, is in the original filing, and I was going to talk about this in a few minutes, there was also a 3 plus 9 month heading on certain things. The reason for that is under the minimum filing requirements, and often as these cases are termed, the label or the lingo used for them, when you have projected data and actual data, the most common practice is to do it by calendar quarter, like 3 plus 9, and then you add 3, and that's 6 plus 6. So that was the label, that the type of filing that Delmarva that Delmarva did, and the add-on. But that was not what was actually done, and that was made very clear. So I can show you that right now in response to your question, which is, if you will, once again, since we're on tabs A and B, if you would go to tab A, to the testimony portion, okay, page 4, please, of Mr. Ziminsky's original testimony that was filed in August. He gives this explanation I just gave, which of course staff and DPA received. If you start at line 10 on page 4, it says, please describe the data included in the test period in this proceeding. It says the test period used in this proceeding is a, quote, 3 plus 9, close quote, 3 months actual, 9 months forecast. However, the data in this test period includes 5 months of actuals through May 2017 and 7 months of forecast ending December 2017. So right there it is. It's that type, and that's why these labels went on there. Could it have been clearer to put 5 and 7? I almost said 8. That would make us too many months. And then later, 8 and 4. Well, yes, and that was actually done in the supplemental testimony and highlighted when the schedules came out in the supplemental testimony. That was 8 and 4. But he goes on and explains that this is just the type of filing that we're actually adding bonus months because we're not filing till August. So we want to put in as much actual data as we can. This was an effort to be as accurate as possible, not to deceive anybody. Why is the company labeling this filing as 3 months actual, 9 months forecasted? Minimum filing requirements definition, section 1.2.3.1 states, if the filed test period is other than the test year historic period, 3 months of projected company data as filed shall be updated to actual total company data and provided to staff and all parties within 60 days after the close of the quarter, unless at a later date for submitting this additional testimony is otherwise ordered by the hearing examiner. Then, that's the quote from the rule. Then Mr. Ziminsky explains, in order to comply with the definition that is deemed to require the data to end on a quarter month, this filing is technically labeled 3 plus 9. However, the data provided consists of 5 months of actual through May 2017 and 7 months of forecasted data from June through December 2017. Seems to me anybody that read that would understand the labels, and right there it is in plain English, not only what was being done, but explaining why the label was used so it wouldn't create confusion.
So, Mr. Skaggs, one last question on this point, please. So,
yes, sir.
Then how do I reconcile the title of 6 plus 6 months in the schedule?
Yeah, and so once again, the type of filing, this projected, and the definitions appear to indicate in the minimum filing requirements that it should be calendar quarter, or that most people do calendar quarter. That's the way they're written. Nothing prohibits giving more data. That's more accurate. So, once again, this was corrected in the supplemental where it was put on top. And do you have those? You have those copies, I think, of the supplemental with the highlighting that shows the 8+4. So it was done in the supplemental, and we could show you that to make sure there was no confusion. And
I have only one copy.
okay, sorry.
If that'll help, I can explain that really quickly. It's up to you.
Anyway, the bottom line is, yes, they were on there. It's that type of filing, but the actual data was very clearly explained. Thank you. Oh, here it is. Here it is. Yeah, there it is. So he'll bring those around, and I'll continue to show you that this was made even, was reinforced at tab B during the supplemental testimony. And I'd ask you to flip to tab B, the first page of the testimony by Mr. Zeminski. If you go to the first page of the tab B, you will see at line 7 a question, what is the purpose of your supplemental direct testimony? This testimony and attached schedules update the company's direct testimony filing to reflect 6 months actual and 6 months forecasted for the 12 months ended December 31, 2017. Once again, that's to meet the way that the rules are written. But then it says, just like the first one, however, in the company's August 17, 2017 application, a full 5 months of actual data was provided in order to comply with Section 1.2.3.1 of the minimum filing requirements, which requires 3 additional months to be updated to actual data. This testimony provides 3 additional months of actual data to reflect 8 months actual and 4 months forecast. The result is that instead of providing the Commission with only 6 months of actual data and 6 months of forecasted data, an additional 2 months of actual data has been provided. So we are somewhat at a loss to understand why staff and DPA continue and have continued through this hearing to push the point that there's some sort of deception going on here about how much data was actual and how much was filed. In fact, if you look at the last tab in your notebook, G, these are responses to data requests, just so we remove any doubt. One is a DE and it is Delmarva Power and Light Company, Plant and Service Electric, 3 + 9 months ending December 2017. Once again, labeled as type, but if you look across the top of the different months, you will see the actual run through May. This is based on the original filing, a data request response, and then projected thereafter. The same is true on the next 2 pages. So if you get down to the specifics, once staff and DPA start looking at the actual data provided, there's really no doubt about what went on here. So we are at a loss of why this would be continued to be pushed before the commissioners today. Mr. Goodman will explain what he just handed to you.
This is in response to your question, Commissioner Gray. What was handed to all the parties is the attachment 1 or schedule 1 to the supplemental update to actuals filing that was started this whole problem, that was filed on October 18th. And second page of the actual filing lists all the schedules. What I handed you up is Schedule 1. The highlighting on there is original. This came to everyone as highlighted, and it, as you can see, it clearly says the adjustments 8 months actual data. So I thought it was important to answer your question. You asked, well, these were labeled as 6 and 6. You're saying that 8 months was actually provided, and I think that's about as clear as it gets. It's you don't really judge a book by the cover, you judge it by the content. And the content provided has always been with the original filing that was labeled a 3 by 9 was always but 5 months of actuals provided, And even in the supplemental filing, as you correctly stated, was labeled a 6x6. You asked, where is it clear that actual 9 months was filed? This is the very first schedule, which is, I hope, what the experts are looking at instead of just the testimony. And there it is, actually highlighted for them in the original to see.
So, and once again, in hindsight, could the company have used different labels on those schedules? Yes, of course. They were going by type, but nobody anticipated this because it was right in the testimony and thought that the normal course with staff and DPA would be to pick up the phone and ask us. And that didn't happen. Instead, we got the motion. So that's the facts we'd like to straighten out. Now, the law. What is the law?
With respect to do you want this as an exhibit, I assume? I've heard no objection to this. Since the enter is Delmarva Power Lights. Next exhibit, A and B, I guess, whatever the number is.
The exhibits would be A through G. It's all materials from the record or excerpts from requirements.
Okay. So it's already been, okay.
Yes, and could we, I guess we'd ask to label the handout as F.
The additional one that I presented
Handout as F, and we'll get copies to the court reporter.
Should be, I think it should be H.
I just went backwards in the alphabet. I apologize. It is H does come after G in the real world alphabet. I apologize. So we would move those as exhibits for this hearing.
Point of order, this isn't an evidentiary hearing.
I think this is part of his argument as to why there was confusion.
Well, this is all part of my argument. I'm not asking you to introduce them. We don't introduce that evidence and no arguments on it. But, I mean, obviously it's your call, but it's highly unusual.
Well, occasionally something highly unusual occurs, and we live with it. So it's not real harmful, I don't think. It's part of his explanation, oral explanation. And Mr. Skaggs?
Thank you, Chairman. Okay, so the law. What is the law of this commission on dismissals of cases and on remedies for mistakes in filings? First, I would note that the staff and DPA failed to cite a single decision of this commission granting dismissal of a case based on the correction of erroneous data in an application. Unprecedented to our knowledge, and in fact, we know of no decision doing that in any jurisdiction. So this motion, obviously, we would submit, seeks a harsh, unprecedented, and quite frankly, punitive order from this commission. DPA and staff in their initial filing refer to multiple statutory sections. You may have seen that in their motion, but none of them mention dismissal or correction. And we would submit none of them provide any support for the fiction that the DPA staff seek to create here, which is the correction of this mistake, sizable amount, one mistake, and the required updating, which they had to do, would constitute new rates or new application requiring a do-over, a start-over. We would submit, if you look at those sections, there's nothing like that there. Now, in their reply, staff and DPA boil their argument down to section 305. And 305 is at tab C. That's the section they say would require this commission, or could authorize at least this commission in its discretion, to say, this is a new case, you've got to start over. So as you can see, and I won't read it out loud, but basically it says a schedule stating a new rate. The commission may, on readable notice, hold a hearing to the lawfulness of the rate. Hardly controversial. Doesn't include the word dismissal. Doesn't include the word about any specificity about what types of mistakes would warrant dismissal. Anything like that. So this is a stretch we would submit, to say the least. The correction here cannot, as a matter of logic, and we would submit, particularly this filing that includes the updating, could not, as a matter of logic, constitute a new case, and here's why. Corrections and changes in parties' positions are very common and happen in every case, I believe, or at least almost every case, often right up until and including in rebuttal testimony from the utility right before the hearing. In fact, I've been before this commission to argue about whether a change in the data was allowed as late as rebuttal testimony or after. This commission has dealt with that issue, and that's much later in this case. Much later in the case, much less time for DPA and staff to try to figure out that correction and oppose it. And that's the way the issue comes up, not something this early in a case. So, most pointedly on this point is MFR 1.2.3, which happens to be at tab D of your notebook. Once again, I won't read it every word, but basically it says that if you use, like was this case, and as in many cases, the utility uses part of its test year as actuals and part of its test year as projected, that once you get into the case, right, there has to be 3 additional months of projected total company data as filed shall be updated to actual total company data and provided to staff and all parties within 60 days after the close of the quarter. So providing, remember we went through May in the original, so providing June, July, and August was required. And that's the other thing that's in the supplemental testimony she pointed out to you. And that requires the changes of a lot of schedules. So that's required. Now all those changes, of course, would change the ultimate rate that would go into a tariff. It would have to. Any change in a revenue requirement, any other adjustments from actuals, if flowed through, would have to change rates. So, under the logic of staff and DPA, every time someone complied with this minimum filing requirement, they had stated a new rate because they had changed data, which means their case should be dismissed, which means you'd never get to a hearing. Because then they'd have to refile, and then when they filed their 3 months projected data, it'd be dismissed again. So this idea that because there's corrections in the data that would require new rates as being a grounds for dismissal runs completely contrary to what utilities are actually required to do in the way of updating within a case. So that cannot be grounds for a dismissal. The fact that you're updating and data is changing. It changes throughout the case. In fact, it's required to change. So as we showed you, really there's just a few schedules changed, like 3 from the mistake. The others were all updates as required. So in our view, we don't know how that could work as a reason to dismiss. Now, what is the law actually, and what is this commission, what do the rules and this commission said about when there are corrections? So if you look at tab E, that is minimum filing requirement 1.3. And under that, section 1.3.1, second sentence, says, this filing requirement shall not prohibit the utility from subsequently submitting further testimony exhibits in a timely fashion as necessary or proper to address issues raised during the investigation of the application. We submit that's pretty much directly on point. There was updating being done, as it should be doing. Delmarva was continuing to review its application to make sure it was all correct, and it noticed this new issue, this mistake. So it promptly, as soon as it could get everything together and make the correction, and put it with the supplemental data, notify staff. Remember, we're very early in this case. It's not due to be heard to an evidentiary hearing until March of next year. So they did that. We would say this minimum filing requirement says this commission doesn't play gotcha. It doesn't say dismissal. It says, yes, of course you can file those things. It doesn't say the schedule shouldn't change, shouldn't be modified to allow more time. But it says that's the way we operate, is we allow those things. Now, if you look further down below the 3 subsections, for the sentence that starts with modifications, it says modifications in test period data occasioned by reasonably known and measurable changes in current or future rate-based items. And then it goes on and starts with expenses, because that's what we're dealing with here. It says, may be offered in evidence by the utility at any time prior to its filing of rebuttal evidence. Now, it does allow for an objection there, and I'll talk about that in a second. But essentially, this is, of course, reasonably known and measurable change because it was a mistake. When they look back in the numbers, they found, oh, this is certainly a mistake, and we can quantify that. We know what it was, and we're measuring it, and we're saying it now early in the case. So once again, this, in our view, would be a section that says, of course, we don't dismiss people. We allow you to amend. It's typically used, Grant, it's typically used when later in the case, when other data occurs, when other events occur that produce data, or there's a projection of stuff that's reasonably known and measurable, that the utility can put that in. And that's often a subject of debate and decision before this commission. But this, of course, this mistake early in the case would also clearly be fall directly under that, or certainly shows the intention of this commission to allow the corrections of those types of mistakes. It does allow objections. Typically, you see that if you look at the rest of that section does allow objections. Typically, that's whether to allow, and that's what you look at the case decisions in this commission by hearing examiners. Do I allow that correction or not? Because you're bringing it in the day of trial or very late. And that's the DeMarva case that's cited by the staff at DPA. You just brought it in too late. We're not going to allow it. There's no talk in those case decisions of dismissal. Now, yeah, and so there is the case decisions. Well, before we leave rules, this commission did consider in 1998 whether it would like a more harsh rule with respect to dismissals. And I didn't put this in your tab, but it's Exhibit 5 to our response paper. It was from PSC Regulation Docket Number 4 back in 98, and their staff proposed this addition to the minimum filing requirements. Any modification arising from issues not joined by the original application shall constitute a new application and be subject to all applicable filing, test year, test period, and other requirements hereunder. That was proposed. This commission declined to put that into these rules. Once again, we would say all these, when you add them together, this commission doesn't run that kind of process, that it declined to say, just because a new issue comes up and you have to address it, we're going to make you start over. So this was put to this commission many years ago, and it said, no, we're not going to be that punitive. Case decisions, I referred to one with the Delmarva case where the hearing examiner disallowed it because it was too late. Didn't talk about dismissal. The Artesian case we cite, the Artesian water case from 2000, allowed a correction of a mistake that was essentially an increase in 15% of the original revenue request. It was prior to rebuttal, and Artesian gave a reasonable explanation for the need, for the correction. This wasn't new data. They looked back and found a correction. Actually, there were certain race-based items missing from their master list, and that was allowed. And that's common sense. There was no reason to impose dismissal or even not allow them to correct the mistake at that time. So the big picture here is a logical and comprehensive system is what we have that clearly allows for the correction of mistakes and authorizes dismissals only for fundamental problems, and that's under 1.5, and I didn't touch on that, but that's for fundamental problems where, and if you look at 1.5, that's minimum filing requirements 1.5, that's the one where the staff reviews filings, and if it fails to meet either the requirements for either the instructions or the format, it is required to, within 15 days, provide notice to the utility, and then the utility has 15 days to fix those. I believe that is actually, if you're interested and spend a lot of time on it, at tab F, and that's penalties for noncompliance. But here, I didn't spend any time on it because here there was no notice from staff or DPA that there was any deficiency to trigger 1.5. There could have been. They didn't do it. They still haven't done it. No notice, no period, opportunity to cure. Instead, they just moved to dismiss. So that's where those kind of fundamental failings is where this commission says perhaps we'll look at making you start over. And we would submit that's a long ways from what you're faced with today. So that is really about the correction. Now, there is an argument about the updated filings, the 3 months, and how they violate the 60-day requirement for the filing of three months additional actual data. And I already explained that somewhat, but that we're really dealing with a 5-month, 7-month, and then adding the 3 to make it an 8-month, 4-month of actuals, not 3/9. So the argument from staff runs like this, or staff and DPA runs like this, that DPO filed its application with 3 months of actual data. We know that's incorrect. January through March. Therefore, DPO was required to file actual data for April, May, and June by the end of August. That's the 60 days, right, requirement. And that DPL did not file its updated actuals until October 18th. That's the supplemental testimony we're talking about. That included all those updates. And if that were, in fact, the facts, there could be an issue with a violation. Doesn't mean it would warrant dismissal, but there could be a violation. Well, of course, the actual facts that I explained in response to Commissioner Gray's question was this was a 5-month filing of actuals, and then there was an update for June, July, and August. That was filed in mid-October. So from the end of August, 60 days would go to the end of October. So this clearly, the updates were filed within 60 days of the end of the actual period, the actual data period, which went through the end of August. So there's no violation of that minimum filing requirement based on what actually happened. Now, if you step back from that and say, even if there's something amiss here about this filing and the timing, what should be the solution? Should it be dismissal? We respectfully submit, of course not. It should have been, we don't understand what happened here. Was there 5 months of data? Does this warrant dismissal? And remember, dismissal. That's I already made the point. And I brought this is what, and Chair Winslow asked, how much? This is how much would be a start over. All these schedules, 10 witnesses, a complete new application, determination perhaps of a new test year, a new test period, and everything redone. Hugely expensive. And a huge setback for a utility who's out trying to say, hey, I made a mistake. I just want to correct it, and let's keep the case moving at some reasonable place. And I think that if you like your question answered fully from the company, Commissioner Winslow, I think Mr. Goodman can provide that answer on the expense.
And I could do it very briefly, Your Honor. As your question was, what is the penalty? He showed you what it would take us to put this back together again. So let's say there was a dismissal today. We would have to go back and recreate this case with, updated time periods. That takes quite a while. Currently, since we filed the current case on August 17th, as you know, rates go into effect subject to refund 7 months later. If this were dismissed, it would take us, let's see, today is, this is October, November, December. So December would be before we could get another case filed. 7 months from that date would be in July. So we would have lost, depending on how quickly we can put this together, a minimum of 4 to 6 months before we could put rates into effect. If you average it out at $2 million per month, the answer to your question is if we can put it together quickly, there is an actual real-world dollar-for-dollar loss of $8 million to this company. And if it takes us a little more time to put it together, we usually take several months to put a case together, it would be an actual dollar-for-dollar $12 million direct loss to the company because you dismissed the case instead of giving more time that they are asking for. That's it. There's your answer.
And I will have one short segment, and then I will be done. And I appreciate your patience, commissioners. And this was the last topic as I started, I said I would address, which is practicalities and fairness. This commission, to its credit, has always placed a priority, I would submit, and the company would submit, on the practical aspects of running efficient, predictable, and fair rate cases. Dismissal here would be unprecedented, harsh, and unwarranted departure from how this commission has operated. DPL has offered to take any and all reasonable steps to prevent any prejudice or harm to any party or customers from this mistake. It has offered to modify the schedule. It has proposed a schedule, I think, in response to Commissioner Gray's question last time about could you agree, what would be the new schedule here if the case was not dismissed? And we have received a response from staff and DPA, and they're roughly a couple months, I think, difference. I do believe that could probably be worked out if this was sent back to the hearing examiner. But there's no attempt here to jam anything down anybody's throat. We want to give them a fair amount of time to understand that correction. Now, you've seen it, and it's more complicated, obviously, than I showed you, but certainly nothing that would require another 4 or 6 months. But we want to give that. So that should not be a prejudice. Also, there was some indication of concern from the staff and DPA that when the 7-month rates go into effect under Section 306B, 7 months after the filing, that those rates could be based on a $31 million increase, those interim rates, as opposed to the 24. And I'm here to represent to the commission that will not happen. DPL will base its 7-month rates under 306B on the $24 million increase in its original application. So there will be no harm to customers, even temporarily. Now, of course, everyone in the room knows that utilities rarely get all they ask for. So to say even the 24, even if we put 31, that it's subject to refund those interim rates. So that probably would be no harm. But to make it entirely clear, no one will be harmed, even temporarily. DPL will base its 7-month rates on the $24 million increase in its original application. So I think there were some other concerns. If there's a need for additional public hearings or notice, Delmarva would be willing to do that. So we don't understand what would be the harm to any party or customers from continuing the case with some modifications in light of all Delmarva is willing to do to prevent prejudice, as opposed to dismissal. We've already talked about the cost to Delmarva as far as the practicality and the inefficiency imposed by that, as opposed to continuing with the current application, making adjustments, extending a schedule, and working through it, as opposed to a complete start over. And the efficiency to get new experts, get a new opening order, have them brought in, an all-new schedule months later, just seems to make no sense to us. Finally, there's a broader impact. We want to just mention this, which is dismissal for this type of correction will be heard in the capital markets. Investors follow rate cases. This is part of the Exelon. This is under the Exelon umbrella now. And a dismissal for the single mistake, I'm afraid, would make the Delaware process stand out. And I think it would probably stand out in what would not be a really great way. It could signal investors that utilities in Delaware cannot rely on a steady and predictable process for rate cases, that a single mistake correction, granted this one is sizable, could end up getting you dismissed early on because staff and DPA will not work through it with you, even if you're trying to take all steps possible to avoid any prejudice. And the commission then would throw you out and make you start over months later at huge expense. So that, of course, could raise the cost of capital for utilities, for investors not wanting to get involved in that, and ultimately, would increase rate customers. Now, we don't believe that's warranted. We don't believe that's what this commission has done in the past. And we believe the right thing here would be to deny the motion to dismiss and to send it back to the hearing examiner to take whatever steps are necessary to address whatever claim prejudice, including a new schedule. So thank you for your patience with us, but we wanted to clear this up as much as we could today. Be glad to answer any questions.
Thank you, Mr. Skaggs. Representative Kowalko.
Yes, Mr. Chairman, thank you. A couple of things I'd like the commission to consider in this matter. Number one, I think most importantly, in the conversation we just heard, the testimony we just heard, 1998 is not a precedent-setting case for this matter. It's not even equal the matter before us about dismissal. So I would hope that the commission understands that that is not some kind of precedent setting. And then there was a reference made to the fact that the PSC cannot point to any case where they've mandated a dismissal. And I would posit that can DPL cite a case that went forward when they had such an increase projection of such magnitude over the original filing. Because that's the way you want to compare those kind of things. They're theoretical, they're hypothetical, they're not based on any kind of law or judgment of law. And then thirdly, I want to offer their own evidence on page E, the last sentence. And notwithstanding anything to the contrary in 1.3, the commission presiding officer hearings that may permit the utility to offer an evidence, the modifications contemplated hereunder simultaneously with the filing of rebuttal evidence. So I would say, and I would posit, that the 6 point whatever additional filing should be filed in this case under rebuttal evidence, should not become a part of this active case now, midway through the case. And we are midway through the case. We passed many scheduled dates. We're 2 days before the public comment. And I, quite frankly, I take issue with the fact that it's only $1.04 more a month for the average family. If you're in the predicament of some of these families, that's not a dismissive number. And I find that the culpability of Delmarva Power and Light is sort of suspect. I mean, if you want to, in the middle of an active case, if you want to start transposing reference dates, reference revenue dates, and come up with one that suits your revenue request more, I find that a little bit of a deterrent to a fair and honest hearing on behalf of the public, on behalf of the ratepayers before this commission. So I reinvigorate my support for a dismissal.
Thank you, Representative Kowalko. Mr. Quinnen?
Yes, Mr. Chairman, members of the commission, I'm Mike Quinnen. I'm with the law firm of Pritchard Barton in Richmond. I represent the Delaware Energy Users Group, which is a group of the large industrial customers of Delmarva Power who take service under the GSP and GSP rate schedules, and supports the motions that have been filed by staff and DPA for all the reasons they cite. I just wanted to very briefly explain how this kind of change midway through a case impacts the industrial customers. When a new rate case is filed, when this rate case was filed, the first thing that I look for, the first thing that the members of the Delaware Energy Users Group want to see is how is this going to affect our bills? And those bills are big. They're much bigger than residential customers, and the impacts are really significant to their business. So I look at the tariff schedule that sets out the rates they're actually going to pay. And I look at the testimony of witnesses like Witness Tanos and Witness Santa Cecilia who tell me how this rate increase that is being requested has been allocated to the different classes, and how the monies that have been allocated to those classes, including the industrial classes, are going to be assigned to the different rate schedules, and how those rate schedules are going to be designed. And then I can tell the members of the Delaware Energy Users Group, well, they're going to be asking industrial customers to pay this much more, specifically, and it's going to increase your bill this much more. And the problem with the kind of update that we saw in late October was I knew that there was going to be almost $7 million increase for the whole company, but I have no idea how much of that is going to be assigned to the industrial customers or how it's going to affect the rate designs that are reflected in the tariff schedules, because we don't have new tariff schedules, or what it's going to do to their bills. And the Delaware Energy Users Group and its members need to have that information so they can decide how to participate, how much analysis to put in, what kind of proof they're going to need, and that's information they need pretty much at day one if they're going to participate intelligently in the case. So
they are seriously handicapped when they find out that overall rates are going to go up almost $7 million, but they have no idea at all how much their rates are going to go up. And you can address that in the schedule, or you can address that by going back to square one and starting over. But either way you do it, it's going to require that all customers be afforded the time and the opportunity to understand how a $7 million increase is going to impact them so that they can participate intelligently in the case. So it effectively puts my clients back to square one. So for those reasons and the other reasons cited by the PTA and staff, we support their motions.
Thank you, Mr. Quinn. Mr. Walsh?
Thank you, Chair Winslow, Commissioners. I'm going to go in reverse order here because I think given the amount of argument with Mr. Skaggs, it would probably be easier for all parties if I take that approach. First, I want to mention that with regard to the statement that there's no harm to customers, even temporarily, this entire idea misses the fact that this case was noticed, had to be published, affidavits of publication filed to all ratepayers. I was at the public comment session. I've seen the public comments come in saying, can't afford this, we're senior citizens. And, none of those ratepayers knows that this $7 million is out there. That's a big problem. That is such a coarse scraping on public interest. I can't fathom why Delmarva would come in here and say they're not even harmed temporarily. They don't have any knowledge whether they're being harmed. And that's a problem. And that is in direct derogation of the rules requiring the public to be noticed of what actually is. Now, there was a mention that under Section 1.5 of the minimum filing requirements mentioned today, and it was also in Delmarva's opposition, that we should not be heard to object to these, quote, supplemental filings to actuals, because we had our time, and that was September 1st, and they were going to respond on September 15th. If that is true, if the Commission were to accept that, and we are guilty of not knowing their $7 million mistake back for August 31st, the one which they brought to light October 18th. Well, we can't object to it now. Time's passed. That doesn't seem to be fair to anybody. Staff, DPA, Delaware Energy Users Groups, NREC, representative, any interveners, the public. You can't make up the rules as you go along, and that's what they're doing here. I wanted to clarify a couple cases that were referenced. The Artesian case. Let's compare the $7 million at stake here to the bottom line in the Artesian case. That was allowed because it was two utility plant items that weren't included on a general ledger. That's their support. That's just like $7 million. The 1998 case, where they alleged that staff already tried this and was shot down. That's just not accurate. That argument from staff was withdrawn and it was not considered in Reg 4. I reviewed that case. That was not part of the actual language. The the complete argument is that the new modifications, not in the original application, should have set time periods or cutoff dates to be considered. The way they craft our argument as being shot down is just not accurate. The case shows that. I'll mention this just once. Mr. Skaggs mentioned the word deception a few times. We've never said deception. It's not in our papers. We're not accusing anybody of deception. What there is a misconstruction of the rules to the great prejudice of the ratepayers who still don't know about this case. The $7 million. I also object to the use of punitive. We're not trying to punish them. No parties are trying to punish them. If they are punished, it is of their own doing, and that is a risk that they inherently have. They made a mistake. If they are let to slide on that mistake by crafting these MFRs in such a way that allows all this to come in, then the punishment is really on everybody else, to their pecuniary gain and to the unknowns, dollar-wise, again, of the public. You cannot do that, notice-wise. It's also interesting, I note down, underlined, that Delmarva described this $6.8 million filing as a new issue. It is at least that, and pardon if that sounds a little sarcastic, but clearly it's more than a new issue. Query whether the commissioners or any of the parties had the same problem I did in following the 3 9 months, 5 5 months, 8 4 months, things that were underlined that still just aren't clear. And the only thing that does is highlight the fact that the parties, interveners, and the consultants are dealing with a new case. And they have to have time to deal with it as a new case. We don't allege that that was deception, but by their admission, it was a mistake. It was a big mistake. It shouldn't be on everybody else to make the corrections. There was also a statement that Section 305, Title 26, references only the Commission's ability to schedule a hearing, but nowhere in there is there any mention of dismissal. So ostensibly, you don't have the authority to dismiss under that section. Well, dismissal isn't excluded under that section either, and clearly under the Commission's jurisdictional powers under Title 26-201 for sure, there is the power to exercise discretion and fairness and justice to the public interest in balancing the interest of the utilities and the public to dismiss a case just like this, where there is a significant error unknown to the public that is going to require a lot of work which, in terms of the MFRs, we no longer have time to September 1st is passed. So I guess that was our mistake and missing their mistake. I think that's what the argument boils down to. I had mentioned, again, the tabs that Mr. Skaggs referenced between A and B, going back to the modifications, and I'm glad that the Commission highlighted the fact the 6 plus 6 months in the latter supplement. Put an asterisk by it. And there was a comment that these filings agitated staff in the EPA. We're not agitated. Our consultants might be agitated when they try to figure out exactly what's going on here. Because the landscape has changed dramatically. $7 million changes the landscape. It's a new game. They've put in new players. And we are entitled to dismissal so that we can start this process again. Not only for the parties now in the case, but for the public that has no knowledge of the $7 million. There was a mention that our facts submitted, staff and BPA submitted facts that were inaccurate, and that this dismissal of this case would be unprecedented. It's difficult to consider the inaccuracy of our facts when A, that's not true, and B, you have supplemental filings that nobody at this point, with the extra $7 million, knows the effect, which are facts, which are discrepancies, and how we'll deal with those, how our consultants will deal with those. It's a new game. It is a new game. They filed anew. That was their mistake. It's not a new issue. It's not a supplemental MFR filing. There was mention of the roughly $1 a month as not, in light of the new filing, $1 a month extra to each customer. There was no discussion as to exactly what type of customer that was. If it was a residential customer, you need only read some of the public comments to know that $1 a month is a big deal. That's unfortunate, but it is a big deal. The timing, I would ask the Commission to consider very closely the timing of what happened here. Dates passed, new filing comes in. We're trying to ask for backup. We're filing motions. We're trying to stay discovery. We're being sent things that are, for example, what Mr. Goodman handed up as, well, this was filed, this is, I don't know which exhibit that was, but
H.
and this was marked into testimony today as an exhibit. This is part of the testimony of eBridge. This isn't on Delafile.
No, that's
or part of the supplemental eBridge.
That's not.
Work papers. I'm not reading my own notes. But it's not part of Delafile. And this was received on the 26th of October, more than a week after their new rate increase filed. I don't know who's scrambling more to keep up with the new case, Delmarva, with parties receiving all this new information. But
this steel information, the word all. Besides the error that's been pointed out by Delmarva Power and Light, what other all is in all?
We don't have these schedules to back up what effect this $7 million has on the various components of the case. And our consultants, parties consultants, need that. That is the flow. Now, the smaller, the filing is one part, but what it impacts and to what degree is not known and it has not been figured out yet. And the time to say that's not sufficient, and the time for under the original scheduling order, the procedural order, puts us at a tremendous disadvantage. We're playing under those rules, but in a new game.
So are you saying if it was a $700,000 mistake rather than $7 million mistake, we might not be here today?
I'm not sure how to answer that. Only that we are here today with a $7 million mistake, and
If it had been a $700,000 mistake, wouldn't it affect the same schedules you're talking about that you don't presently have? Regardless of the figure, it's going to, a change in that number is going to affect the same number of schedules, it seems to me.
Potentially. I don't know how to, and I'm not being evasive, Chairman Sub, but we don't know what we don't know, as they say.
I'm a little curious because I'm not very technologically advanced. Commissioner Gray down here is. But usually when you have an Excel spreadsheet or whatever replaces that, you take that one number out and you plug in a new number and you push the button, and you know what, they come up with different results. And I'm sort of having a hard time understanding the depth of the prejudice to the DP&A and the staff in that particular issue. Commissioner Gray, do you have any comments on it? Any questions on it?
I think it's a very interesting question as to whether the amount, if it were to change, would we be here today? I'm still not sure I have an answer to that question that was raised by the two commissioners here. I have some different questions, Mr. Chair, but I just assume take them later.
Okay. Sorry, Mr. Walsh, for the interruption. Right?
The question remains, would it be different if it were $700,000
Correct.
mistake? I don't know because I don't have
okay, fine.
the ability to talk to the consultants and
Fair enough.
see.
We can answer that if you would like.
That's okay, thanks.
I could say that it would potentially be less time to do so. Because the picture's smaller, maybe it would be easier to filter things, but it's still restarting the process. And if there are deficiencies, again, that deadline passed September 1st. And I think any ratepayer, as staunch as they are and should be, I would think any ratepayer should be able to know about $700,000 as much as they should know about $7 million. So I will, one note in terms of how we have been presented in this, and I mean staff and DPA. It was, in terms of trying to get this figured out and arrive at a resolution. Up until just, I think it was a couple weeks ago, we were not, not until yesterday, the DPL, Delmarva, offer more than a 2-week extension. So, if it were $700,000, 2 weeks might be problematic. When it's $7 million, and nobody out there has notice of it, I would say that we deserve, if not it should be extended by way of their having to file the case and give the public notice and restart this, because it is in their error. So I will end my rebuttal with that, unless the commission has any questions.
I noticed that there's no, the counsel for DENREC is not present, or is present. Your comments, or you share the comments, I assume, of state DPA, or do you have any additional comments?
Chairman Winslow, Commissioners, as you know, as DENREC stated in its petition or joinder, our interest really is in energy efficiency in this docket, and we rely on DPA and staff to address ratepayers' interests. So we don't have anything substantive to add to this discussion.
Thank you, Ms. Scott. Mr. Kowalko, the arguments are over. Commissioners, any questions of the parties?
Please,
Commissioner Correa.
I have a couple of questions and then
1 second.
Might we have a very short...
5-minute recess.
you said that you were beginning of all these things this year.
Thank you. Thank you.
Money? Yeah. And we are
Sit and reach out and let's go. And do whatever we do. Yes. Thank you. Thank you.
You can keep that, you can keep all these things that I do. Only thing you can't get is my wallet.
Thank you. I saw him scribble out. I was getting ready to. I'm trying to find it for you.
I think it's under.
Oh. And I thought I was going kind of slow today. Yeah, better
I know when you start out like
okay, but you still needed it.
I gotta stand up.
no trouble.
He said 5 minutes, but do I have time for a smoke? Yeah, I'm just throwing stuff around.
They set their business model and it's not up a year ahead of time. You can't determine that unexpected expense. And they try to confuse that. Delmar saying, well, we're not going to ask for that. That doesn't matter. What you're getting wrong with it, not what you're going to ask for temporarily. That can be a draw. That's a little crap that they get away with.
I thought he would talk about, those 8 companies are over regulations are the huge economic drivers of the state.
That's what I'm saying. Projected expense of $1 million and it grows to $1.25 million. That's $250,000 less than you have for hiring new employees and or keeping old employees and or product improvement.
Yeah, investing in the plant.
Yeah.
I'll play one of them.
This will be going to the court for a minute.
I like the way they selectively point out what this commission can or has done and what they are allowed to do by their determination.
Yeah, right.
I'm sorry, Your Honor, you can't hang me for killing those 30 people because I happen to know you have a connection with a rope maker. How could I depend on you to give me an adequately strong rope to snap my neck before, rather than decapitate me? Jesus Christ. Talk about obscurity, obfuscation. I thought I was good at that. I'm no match for these people.
Thank God they're potential legislators.
Yeah, you guys run for office. I can use that kind of thing to try to win a debate when I'm up against it. God.
Either that or you should be paid like a $300 an hour lawyer.
Yeah, that's right. I was taking notes and then I ran out of pages. I said, I was just taking notes up there, misrepresentation of reality. You can't rule against this because you've never done it before. It's never been done before because, why? Because you've never asked for a 30% increase in the middle of a case before? Well, 1998, Jesus Christ. Yeah, in 1814, we went down to New Orleans and fought the British. Mighty.
Want me to cut it off?